it. Then we go, or whatever, or you order us to fetch him and bring him here tomorrow, or whatever, whether he's sick or not. I mean, I'm not saying that your lordship is going to do that. I'm just exaggerating for effect. Then, when the matter then starts in his presence, let's say, following that postulation, then, as I say, the state can do or say or apply to do whatever it wants to do. But what it cannot do, my lord, is to say your lordship must receive sensitive, most sensitive information on the speculative basis that maybe the issue may arise, number one. Number two, they also cannot disingenuously, and I'm saying that again, latch on to the fact that he happens not to be here this morning and say, then there's an opening for us to bring the medical evidence. Let us address the matter as it should. Let me address your lordship on the issue of the presence or absence. If your lordship is satisfied on that issue, then we deal with the 106. If, as a result of whatever happens, I have to ask for a postponement, then I will. If the state has to ask for a postponement, then it will, and then we'll deal with it on that basis, Madam. Not on some surreptitious and backdoor manner. Secondly, my lord, let me just address the direct question first. Mr. Zuma says, my lord, and your lordship is 100% correct. I can't quibble with that. That it is the section 106 is also to his advantage, the proceeding thereof. That is stating the obvious. He's the one who brought the application.
Otherwise, presumably, he wouldn't have pursued it.
Absolutely, that's exactly what I'm saying. He's the one who brought the application, so presumably it must be to his benefit. But the point is this, my lord, and I want to follow your lordship's logic a bit. Let's assume, for argument's sake, we do the 106, it's successful, and then the 106.4 is also successful. Then that's the end. Again, where does this issue of medical records come in? Nowhere. Because at that point, it doesn't matter if Mr. Zuma has got a headache or whatever, because the 106 matter will have been resolved in his favor anyway. So your lordship is quite correct. But that actually makes the matters worse. That's even more reason why this thing is completely irrelevant at this stage. Because if as we hope, we are successful in persuading your lordship that 106.1H and 106.4 should be granted, then that's the end of it.
Yeah, I don't know whether that's a complete answer, Mr.
Well,
Mpofu.
it's not at this stage.
Sorry, just hear me out, please.
I'm sorry.
In every trial, matters come, subpoenas get issued, documents get handed in. Well, not in every trial, many trials. And eventually the trial gets decided on some other basis. And those documents, in retrospect, might then not have had all that much relevance or significance. But that might or might not happen here. So
exactly, my lord. But then those documents don't get tendered. That's the point I'm making. You don't then say, my lord, here's a person who's they might call some witness who's a doctor or an accountant, maybe. But for now, they're doing a Section 174 application, for example, for a discharge. And then you say, no, let's have that accountant and the doctor and the engineer's evidence. What if he gets acquitted in terms of Section 174?
All right. Any further submissions?
No, my lord. Simply to say, my lord, if your lordship, we'd like your lordship to make a ruling, a specific ruling on the issue of the handing up of irrelevant and confidential medical records, so that we can take instructions.
Yes.
I'm sorry, my lord. I'm sorry, Mr. Yes. Mr. Masuku wishes me to emphasize the fact that the purpose for the handing up of these documents has not even been explained. It's simply to say they must be in your lordship's chambers. For what? Is it for the issue of Mr. Trengov mentioned the issue of medical fitness to stand trial? Well, if that is the issue, then that issue is definitely not before you.
Yeah.
If it's, as your lordship put it, some anticipatory issue, about his presence or absence today, well, then that issue should have been raised by us. If it's about parole, then it's completely irrelevant and abusive of the process.
No, I don't think. Yes, no, I don't think anybody suggests that it's relevant if it's on the question of parole. Parole's not before me.
Well, exactly, my lord. Then why is Mr. Skakane here? Mr. Skakane is here because these people, the NPA, have subpoenaed the records from correctional services. Yes. I can tell you, my lord, your lordship knows this, but just for the record, that Department of Correctional Services and Mr. Fraser and all those people have got absolutely nothing to do with the issue that was potentially between us and the NPA. So, and in the affidavit, my lord, we have made a specific objection to, in fact, now it's prophetic, at paragraph 24, my lord. So, although not yet in possession of any concrete proof thereof, it is once again Mr. Zuma's strong suspicion that the NPA and or its counsel sudden change of heart, that is now on the basis that before they said the doctors are finding each other and now suddenly they've changed, is unduly and unlawfully caused and influenced by external political considerations concerning his release on medical parole. That's exactly what Mr. Zuma says. Before we even knew this, which has become the subject of political football by right-wing political parties and self-styled non-governmental organizations. If true, this would constitute yet another additional basis for rejecting Advocate Downer's and others' title to prosecute for once again playing to the political gallery. That's paragraph 24. In other words, this whole rigmarole that is happening now might well be part of the Section 106 objection about playing to the political gallery or doing the bidding for AfriForum and the DA by you abusing the process of this court. And he says that can be the only explanation why they are hell-bent on deliberately and mischievously conflating the separate and unrelated processes pertaining to this paragraph 25, my lord.
Yes.
That can only be the only explanation why they are hell-bent on deliberately and mischievously conflating the separate and unrelated processes pertaining to 1, this plea in terms of Section 106, 2, the subsequent questions of fitness to stand trial, and 3, the most recent issue of medical parole. It cannot be clearer than that. So that's a stance that Mr. Zuma put, my lord, even before this rigmarole was attempted in this court, to say that there is a clear attempt which goes to the Section 106 misconduct issues to play to the political gallery and do the bidding of the DA and AfriForum. And these documents, which are the subject matter of fierce litigation, to be now handed up to your lordship. I can bet, my lord, that in one of the affidavits in that litigation, somebody in the next week, if your lordship takes this, will say, oh, this is much easier now, because, by the way, those documents are in Mr. Kuhn, in Judge Kuhn's custody. So all that this other court needs to do is simply also to extend the hand of judicial supervision to those documents. We cannot allow that, my lord. This court cannot be abused in this manner while your lordship is... For something, as I said, that has not arisen. I would understand if it was relevant. We could have the debates about the extent of relevance. But right now, there's zero relevance of this because it's based on an if, and a big if, which has not materialized.
Yes, Mr. Tringo, in reply.
Lord, firstly, in response to my learned friend, Mr. Sikakani, who appears for the witnesses, these subpoenas were served between the 8th and the 13th of September, in other words, between a week and 2 weeks ago. They had a reasonable opportunity to take advice or to raise whatever objection they have. It is not good enough for them merely to arrive on the day and to tell you from the bar that there may be some objections. So they're not entitled as of right to resist these subpoenas on the basis of those suggestions from the bar. But, in fairness to them, we'd be happy if your lordship were to give them, say, a week to launch an application to have the subpoena set aside. So we would suggest that the witnesses be called up, that the documents be handed to your registrar, that they remain with you in your custody, with leave to the witnesses to apply within a week to have them released from custody. Because that would completely address my learned friend Mr. Sikakani's objection. But as matters stand at the moment, there is absolutely no justification for their failure to honor the subpoenas. As far as my learned friend Mr. Mpofu is concerned, the history of this matter is that the Surgeon General's doctors who treat Mr. Zuma rendered reports on the 30th of August 2021 in which the bottom line is that they say that he is not fit to stand trial. The NPA's doctors rendered a report on the 13th of September 2021 to the effect that he is fit to stand trial. Mr. Downer asked Mr. Zuma's attorney whether the Surgeon General's doctors accept the conclusion of the NPA doctors. He asked them on the 14th of September, that's in Annexure AA to Mr. Downer's affidavit, and since then on Saturday, on the 18th of September, he asked them again. They didn't respond to those requests. Instead, yesterday afternoon, we get an affidavit to say, and let me say, because we haven't had a response, and in the light of your lordship's ruling, we brought the medical experts down here. They're sitting in court. They came to give evidence as your order had anticipated, only to get a message by affidavit yesterday afternoon to say, Mr. Zuma is not coming, but we can go on with the application. And the reason for him not coming is set out in that affidavit to which your lordship has been referred. But my learned friend started with paragraph 27.2. The only medical justification for him not being here is in paragraph 27.1, which reads as follows. And I remember this is the attorney speaking, endorsed by General Dabula, sorry. Furthermore, I pick it up in the fourth line. Furthermore, and to the knowledge of the NPA team, the treating team is still monitoring the current post-parole situation so as to make an educated comparison and to determine whether Mr. Zuma's medical condition is improving or deteriorating further. They have placed him in what they regard as secondary medical care. It is once again medically impossible to reach a final conclusion while that process is still underway. Due to the advice of his doctors, he will remain in Gauteng to be within their reach. What does that mean? What does that mean? What is wrong with him and why isn't he here? Now, I appreciate that that is not the dispute you're going to resolve today, but that is certainly a dispute between the parties when the NPA doctors say, on the information you have given me, he seems fit to stand trial.
Mr. Drinkhoff, if it's not a dispute to be resolved today,
No.
should it not then stand over to a later date, this entire issue?
Well, but the doctors need the evidence in order to address that issue. And that is why...
But that might only arise if the special plea proceeds today. Then the way it will unfold, in my mind, is the matter will then be adjourned. I will go and write a judgment. And then if, well, depending on what happens, let's say the special plea is dismissed. I decide in favor of the state. Then the trial has to continue. Mr. Zuma must then come back to court. And at that point, his attendance or otherwise, because of medical reasons, will then include the evidence by the current NPA medical team, the Defence Force people, medical specialists, And then presumably at that point also, to put me fully into the picture, these medical records or the conclusions of the medical parole board, I think the entity is called.
No, that's my learned friend's gloss, which is not true.
Yeah, no, but
These subpoenas do not call for any parole documents. They call for medical records. That's all.
No, but I'm saying at that point, those records might assume significance then in this matter as well. Because if they were to the effect that he should be medically paroled and that he's unfit to stand, well, that might impinge on whether he's fit to stand trial. And presumably at that point, those documents would have to be revealed in any event.
My Lord, with respect, he's not here today. We submit that he is unlawfully absent today. We're not asking your Lordship to determine that issue today, but that is a live issue before you. And we ask for that evidence to be placed in your custody because that issue is alive and our doctors would like to see that evidence in order to assess their position.
Yes.
Thank you, Lord.
Anything further? Mr. Dringo, the objection at the moment is raised in respect of these three witnesses that Mr. Sikakane appears for. Are there other witnesses as well
Yes, Lord.
where this doesn't arise?
Well, no.
No, it doesn't arise, so we can...
No, let me say, it doesn't arise as far as I know, but I haven't communicated with the witnesses, so I don't know what their position is.
All right. So they can hand in whatever documents they were required to produce.
Indeed.
And they'll be treated on the basis of confidentiality.
Yes, and let me say this for Mr. Zuma's interest may be a privacy interest which arises when these documents are released to anybody. At the moment, I'm not asking for their release. He can secure his privacy interest the day that my side attempts to introduce that evidence introduce the information into evidence. But until then, it's not his documents, and it's not his interest at stake. Those documents remain confidential in your custody.
But what is the downside, really? These witnesses will just have to be subpoenaed again to bring those documents.
Yes, but then it just means that my witnesses will only get access to those documents, not before the next hearing, but only at some date thereafter. You see, the problem is that the witnesses don't get the documents, they only come to court. That's why they've not been able to see those documents before the hearing today. If they, again, have to subpoena those records, then they will only see them after the next hearing.
Well, they won't see them in any event because they're going to be in my custody until there's an application made for them to be released.
Yeah.
So that inevitably will involve a further court hearing as well, I presume.
Well,
because if it's going to be by consent, then it will be released by consent from the possession of the current witnesses.
As your Lordship please.
Yes.
I'm not sure whether your Lordship suggests I should proceed with the witnesses who have not objected.
My suggestion would be, certainly my thinking is, and I'm thinking out loud, that this is an issue that should stand over for a later date. That we proceed for the moment on the basis that he's not here, that's the he being Mr. Zuma, on the basis explained in the affidavit, and let's dispose of the special plea.
As your Lordship pleases.
Yes.
I think, I'm sorry, my lord. It looks like Mr. Sikakane wanted me to...
I'm a little constrained by your Lordship's comment about time. I just want to be brief, and I didn't really come here to waste anybody's time. My only interest is this, and I think your Lordship has talked about relevance. I was just constrained at the beginning. First,
Mr. Sikakane, if there's any assistance, my thinking at the moment, as I indicated to Mr. Stringo,
yes,
is that this issue must stand over for a later date. It's not going to arise today.
and so it's not relevant for today.
So then you can go.
I can go
I
certainly
want to
back to
carry on with the
Joburg.
other thing.
Thank you.
Yes. And the witnesses may then also be excused, Mr. Tringo?
Yes, indeed.
Yes. Well, the relevant witnesses, perhaps those who are instructing you, can just communicate to them that they are excused. Mr. Mpofu, the matter is proceeding then on the basis of what's contained in the affidavits and taking those at face value that
That's
Mr.
correct,
Zuma it's undesirable for him to attend today, or that he is unable to attend because of his physical condition.
Yes, my lord. And
so far as he has said that is what he wants, he is he's waiving any right to be present today. That's not going to be a
today and tomorrow, my lord.
today
Yes.
and tomorrow, if we have to go that far. It's not going to be raised as an issue that's a defect or an irregularity in any way.
No, my lord, yes. No, thank you, my lord. Yes, just for this public record, that is indeed so, my lord. There will be no objection raised or irregularity raised in respect of today and tomorrow whatsoever, because Mr. Zuma, even though there are medical reasons, has elected to make those arrangements with his legal team.
You accept in the context of Section 159 that it's convenient that the matter proceeds on that basis in his absence, and you ask that I excuse him on that basis, that he's waived any right to be present, and that we continue with the special plea.
That is what would like your lordship to rule, my lord.
Well, I'm not going to rule on it. I'm just simply going to record it.
Yes, to note it as God please.
Does that go far enough, Mr. Trengo, to satisfy
Yes, indeed.
or address your concerns?
It does.
Yes.
Thank you, my lord. And we will endeavor, in respect of the consultations that are needed, to use the breaks so that we don't break. The arrangement is that we will do the consultations during the tea break as much as, unless if some big issue arises, which is unlikely.
Well, there's nothing for the moment.
Yes.
So, yes.
Thank you, my lord.
Mr. Mpofu, as I indicated informally earlier on too, I'm
yes.
grateful to the parties for the heads of argument that have been filed. They are extensive. In the case of your team, they almost read like written argument. It's not just the bare bones like one normally finds in heads of argument, but I've been through them, I've read them, and I hopefully understand them. There's no need to repeat them, please. It seems to me that the crucial issues are, and then this list is not exhaustive obviously, is the definition or the meaning of title to prosecute, whether it's a narrow meaning or whether it's a wide meaning.
Correct.
I understand your motivation for contending for a wide meaning,
Yes.
so you don't have to deal with that in much detail,
Yes.
but it's there. Secondly, I want you to deal please with Porritt's case.
Porritt.
Yeah,
That's
Porritt in the SCA, and what you say about Porritt, because it's been raised. I don't think it's been dealt with in all that much detail in your heads of argument.
Yes.
It's mentioned, but I would like to know what interpretation you say I should place on Porritt's case, and whether, if it's not distinguishable, whether it's not dispositive of the proceedings in this court, because obviously I'm bound by what the SCA decided. Whether you one day want to go there and persuade the Supreme Court of Appeal
another
that they
question.
should change, or they got it wrong, that's a different issue, but I can't decide that in this court.
Yes.
And then insofar as you rely on the instances of lack of independence or bias, whatever you want to call it, on the part of Mr. Downer, both let's call it the founding affidavit, the affidavit that was annexed to the notice that was given in respect of the Section 106(1)H plea, and the plea itself contains pretty much a sort of a scatter approach. The grounds are never specifically itemized and dealt with individually. So perhaps you can just guide me a little bit on
Yes.
that.
No, my lord, thank you, my lord. My lord, yes, your lordship took the words from my mouth. We proceed on the basis that we know that we've piled your lordship with lots of paper in this plea, but on the basis that your lordship has had time to look at them. So we will not be reading those hundreds of pages of heads of argument. And just apropos your lordship's last question. Your lordship will find that thanks to my learned friends, in their heads of argument, on page 2, which is the contents page of their heads, my lord. The issues are actually itemized there.
Yes.
And there are actually 12 issues, and I'll refer to the 12 issues of the conduct, the itemized conduct, which in our team we call the dirty dozen of Mr. Downer.
Yes. No, I saw that. That is what they've done. I did a similar exercise from the founding affidavit. But are those the grounds that you confine your argument to?
Yes, my lord. For convenience, we will use those 12 grounds.
Thank you.
Yes. Right. So, my lord, I wish to address your lordship on 5 topics, including the ones that your lordship has mentioned. One is the proper interpretation and ambit of the phrase title to prosecute as it is employed by the legislature in section 1061H. And that's the issue your lordship was talking about, porrit and so on. And then using the 12 itemized issues as the basis, we will seek to illustrate, my lord, why the section 1061H plea ought to succeed in view of the admitted conduct. Very important, my lord. In other words, we accept that of the 12 items and sub-items that might arise, there are issues which are admitted, or conduct that is admitted. There's conduct that is disputed. We accept that. But we say, my lord, that your lordship can determine this matter by way of a shortcut, for lack of a better word, without having to go to the complicated question of whether oral evidence will need to be led in the section 1061H stage by resorting to determining it on the basis of the conduct that is admitted, because then we can all escape that difficult question. That's number 2. Number 3, we say alternatively why, in respect of the disputed conduct, the matter would probably have to be referred to trial. And I'll explain that. And again, my lord, a caveat is that hopefully we're not going to get there. Then number 4, we'll say the entitlement of the first accused to his acquittal if the section 1061H plea is successful. That is the title issue.
The 1064 issue.
1064, my lord, yes.
Yeah.
And then number 5 is the essential need for oral evidence in respect of the 1064 leg of the proceedings. And I'll explain that. So what we're saying, my lord, is that as far as the 1061H leg of the inquiry is concerned, it is possible to dodge, for lack of a better word, the issue of oral evidence. But in our respectful submission, when it comes to the 1064 leg of the proceedings, it will most probably be necessary, obviously we're in your lordship's hand, it will be necessary to lead some evidence. And one of the reasons, my lord, is, and again I must apologize, your lordship is quite correct, sometimes in the heads, the demarcations were not put as they should. And let me just say this, my lord. Your lordship, one of the issues that I'm sure my learned friends will raise will be, well, maybe you should have had a section where you say, now we're dealing with Mr. Downer. And another section where you say, now we're dealing with the NPA. Because your lordship will concede that sometimes we use those terms interchangeably, and the misconduct obviously overlaps. Because, well, there's no Chinese wall or total demarcation, of course, between the conduct of Mr. Downer and that of the NPA. But in certain circumstances, it's possible to separate that. And the reason why that is important, my lord, your lordship knows that this was made clear a long time ago in the Nduli case. that Section 1061H is really about a particular prosecutor's title. And I undertake, my lord, that we'll keep to the discipline of that, what that case said. But where the overlaps happen, we will indicate them. But the real point I was making, my lord, is that if, using my formulation of the 1061H leg, that clearly would relate to the conduct of Mr. Downer. And the 1064 leg will relate more to his conduct, of course, but more to the general conduct of the NPA. In other words, if we get there, we will say to your lordship, in this particular case, on the facts of this particular case, because of A, B, C, D, E, your lordship should acquit, as opposed to a case where, let's say, it was the conduct was isolated to Mr. Downer's frolic of his own type of situation. And we will be arguing that that is not what we are dealing with here. It's not a frolic of his own type of situation, but a situation where the prosecution itself, because of the conduct, is incurably. So that's the landscape, my lord, that we're going to follow. Now let me go then to the first topic. Then my learned friend Mr. Masuku will deal with, your lordship will know that there are three preliminary points that are raised. One being this issue of the title, which I'm dealing with. The other two are res judicata and issue estoppel. Mr. Masuku will deal with those. But to save time, I'm not going to deal with the one and then he comes in and I'll deal with my sections and then he'll deal with this.
I don't quite know that they're two, they're really one, but anyhow, yes.
Yes. As God pleases, my lord. So I'll also be careful not to stray into Mr. Masuku's area, although, of course, if your lordship asks specific questions, we will deal with them. So then...
Mr. Mpofu, my intention is to interfere with you as little as possible. I've told you what I want to have dealt with, and I'm going to allow you to develop your argument and you take it from there.
I appreciate that, my
I'll
lord.
try and minimize it, but I will from time to time, obviously, reserve the right to ask.
Yes, no. I accept that, my lord. And if I may, I'll return the favor, my lord, by sticking to the agenda, and we will try as much as possible to try and finish the argument within a reasonable time. Your lordship has indicated some problems about tomorrow, so if it's possible to finish today, we will.
Yeah. Well, let's see how we go.
Yes, that's the code, please. My lord, thank you, my lord. My lord, the starting point really has to be, and your lordship raised this with us even on the 26th of May. It was a subject of a very brief debate. What is the meaning of the phrase title to prosecute as it is found in 1061H? On our version, that must be interpreted broadly to encompass all the necessary constitutional, legislative, regulatory attributes that are needed for a prosecutor, whether they are found in the Constitution, in the NPA Act, in the UN guidelines for prosecutors, in the national policy in South Africa for prosecutors. That body of instruments says very clearly what are the essential attributes of a prosecutor. And we will seek to persuade your lordship that a title to prosecute on behalf of the state, on behalf of the people of South Africa, is not something to be taken lightly. That title means you are acting on behalf of the populace. In this country, we say state versus so-and-so. In other countries, they say the people versus so-and-so. In other countries, they even say the queen. But all those are meant to encompass the fact that a prosecutor is there to represent all and sundry. So obviously, my lord, the qualities that are needed of a prosecutor, the essential qualities, must derive first and foremost from the Constitution and what I've called the body of instruments. So that's what we call the broad or wide interpretation. Our learned friends contend that no, title to prosecute means literally, do you have an LLB degree? Yes, tick. Were you employed at the NPA? Yes, tick. Did the NDPP or the relevant DPP give you the delegation? Yes, it's here, and that's it. Then you have the title to prosecute. In all cases, for all time. Well, we will demonstrate to your Lordship through the cases that narrow interpretation is completely inconsistent with our rules of interpretation, the rules of legislative interpretation, let alone the rules of constitutional interpretation. Because this is not a dictionary exercise, my lord, where you say title, then you go to a dictionary and say, oh, what does it mean? I say, oh, no, it means, do you have a piece of paper? This is, by its nature, a constitutional exercise. The Criminal Procedure Act itself is an instrument for the implementation of the rights in Section 35 of the Constitution, the free trial rights. So, Section 1061, which is part of the Criminal Procedure Act, must be interpreted in that light. It's not just a litany of sections. It's a system that has been put there to give life to the Section 35 rights of an accused person or an arrested person, as the case may be. In this case, we're dealing with an accused person, so it would be 35(3) of the Constitution. That is relevant. Now, Section 35(3), my lord, is our courts have said that it lists, I think, 15 particular rights. And the courts have said that those rights are not exhaustive. It's simply, they are indicative at best. So a court in any particular situation must always start there. Is this in line with Section 35(3)? Yes or no? And is my interpretation of this particular or that particular section of the Criminal Procedure Act, insofar as it deals with an accused person, consistent or not with Section 35(3)? The importance of that, my lord, is that, as your lordship knows, the rules of interpretation of a provision of the Bill of Rights, such as Section 35(3), must be done generously. So it calls for a generous interpretation. In other words, an interpretation that is in favorem libertatis, that favors the freedom and liberty of the individual. But in any event, even if one doesn't have to resort to the generous interpretation favored in terms of Section 35(3), Section 1061H itself, my lord, must be interpreted in such a way as to conform with the Constitution. Sorry, I'm just looking for a note. That notion, my lord, is referred to in our heads in the case. I'm sorry. Okay, my lord, I'll give you the citation. Let me just do it the other way around. It's a trite proposition. Legislation must be interpreted through the prism of the Bill of Rights.
Which paragraph on your head are you referring?
No, it's my own notes, my lord. Yeah, yes. I'll find the reference in the head. Legislation must be interpreted through the prism of the Bill of Rights. In Hande, which your lordship knows, this court held, this is the Constitutional Court, that Section 39(2) requires that all legislative provisions must be interpreted, quote, so far as possible in conformity with the Constitution, unquote. Thus, an interpretation which is constitutionally compliant must be preferred over an interpretation which is not. So I'm quoting that, my lord, as a starting point because your lordship is literally faced with that situation here. With an interpretation which we present, which is constitutionally compliant, and one which is not, that comes from the NPA. And the lordship in those situations must prefer the interpretation that is constitutionally compliant. Let us take a pause, my lord, and look at Section 106(1)H. It says that one of the pleas that you can present is that the prosecutor lacks title to prosecute. And then it goes as far as to say, if you are successful, you may demand an acquittal. That's not a small matter, my lord. In other words, you could be as guilty as they come. You could have killed 100 people. But if you find that the prosecutor does not have the title to prosecute, you may theoretically walk. Now, that is not something that you can say is about certificates and LLB certificates and so on. Why would the legislature do that and say, no, if it turns out that that particular prosecutor faked his LLB certificate, then a mass murderer can walk? Surely that can be the real interpretation. The interpretation must be, my lord, that if the prosecutor is not a prosecutor as required by the Constitution, or has done certain things which disqualify, and I'm using that word advisedly, I'll use it when I talk about Porritt and Delport, I'll come back to that, which disqualifies that person from prosecuting. The law, as a matter of policy, is prepared to release that mass murderer. Why? Because that would have contaminated the legal process in such a way that, as the old saying goes, that it is better to let 9 guilty men go free than to convict one wrongly. Now, that's a fundamental basis. I remember this, my lord. This was it stayed in my head, my very first criminal law lecture. When this statement was made, it was sobering. It would be better to let 9 guilty people go free than to convict wrongly one innocent one. And our system is premised on this, my lord. So if a prosecutor, somebody who has been entrusted with so much responsibility as to represent the people, to prosecute on behalf of the people as a whole, commit certain acts, then that entire prosecution is nullified, as it were. Surely that is the real interpretation of the section. And that is why, my lord, if your lordship is doubtful about that, the fact that section 1064 says that we will acquit anybody who is successful in all these pleas, except if you have pleaded lack of jurisdiction. That is, I'm sorry, my lord.
Yes, I have it. I've
Yes,
read
my
it
lord.
again.
Yeah. I'm just paraphrasing, my lord. Yes.
Yes.
Your Lordship knows that it says that except for a plea of the pleas that are listed
That the
in
court has
section
no
1.
jurisdiction.
Yes,
Shall be entitled either to be acquitted or to be convicted.
absolutely. Why was that distinction made, my lord? Surely what the legislature is saying to us, my lord, is that if you've killed someone or stolen something, and then it so happens that you are charged in Durban, and we find that no, you should have been charged in Maritzburg, and you are successful in that plea, you can't be acquitted on that basis. Then you will be tried in Maritzburg. However, if there is a section 1061H finding in your favor, then you are entitled to demand an acquittal. And it goes to what I'm saying, my lord, that this must have been meant for those situations where the title to prosecute goes to such an extent as to contaminate the very exercise of the prosecution.
But
And
a lack of title would also include the absence of the certificate or the appointment.
no, that I consider.
So on ordinary wording, 1064 would apply.
Absolutely.
So
Absolutely.
does that really then assist in deciding on the interpretation of the word title?
No, my lord.
Should it not be sought somewhere else?
No, my lord. The logic is not like that, my lord. If the mere fact that something is allowed does not mean that the relief of the law is restricted to that thing. So we don't. All we are saying when we say wider or broader, we mean exactly that. We simply say that it includes the qualification. Actually, let's use that word qualification, because I think that's the word that's used in Delport. It says that you may be disqualified from conducting a prosecution. And we are saying that disqualification cannot merely mean not having the qualification, the academic qualification. It must mean that you are disqualified from exercising that office of being a prosecutor. And the words that have been used, my lord, and the answer to your question, my lord, actually arises, it answers itself in what I was saying about section 1064, which is a completely different inquiry. So in section 1064, your lordship, in theory, will have, let's say you'll have two accused in front of you. One says the prosecutor did not have an LLB, and therefore I'm raising 1061H. The other one says the prosecutor committed serious misconduct, and I saw him taking a bribe from somebody. I've got a picture of that. And I also am raising 1061H. And the answer to your lordship's question lies in the fact that the legislature, in its wisdom and correctly, does not say that if you succeed in 1061H, then you have automatic acquittal. It's exactly to cater for what your lordship is saying. So that your lordship is able to say, no, Mr. So-and-so or Miss So-and-so, your only issue is an LLB certificate, and therefore, although you are entitled, like everybody else, to demand an acquittal, I will not acquit you. But you, Mr. X or Y, because yours go to the root, and you are also entitled to demand, I will acquit you. That's exactly what 1064 caters for. So that question does not arise that because 1064 postulates that there's an array of there's array of disqualifications from not so serious to serious.
Is that a convenient stage to take
It
the
is,
adjournment?
yes.
I'll make it 20 past 11 if we can adhere to the 15 minutes, please, and resume at 25 to. Court will rise.